Okay, so let's continue from where we stopped, where we left off, right? We are doing Clark and Lindsell. We're still reading Clark and Lindsell. There are a number of older authorities which suggest that a report of proceedings will not be privileged if it is mixed with comments on what took place. Okay, so let's avoid comments if we want to enjoy the privilege. Okay.
Proceedings of courts of justice properly condensed and fair, but it is not entitled under pretense of giving a report. There are a number of older authorities which suggest that a report of proceedings will not be privileged if it is mixed with comments on what took place, that such comments should be kept separate from the report. For example, a paper may give a report of the proceedings of courts of justice properly condensed and fair, but it is not entitled under pretense of giving a report to add comments of its own or to display facts not brought forward in the proceedings. 735 As Lord Campbell CJ said in Andrews v. Chapman 736, if any comments are made, they should not be made as part of the report. The report should be confined to what takes place in court, and the two things, report and comment, should be kept separate. In Lewis v. Clement 737 the libel suit on was headed Shameful Conduct of an Attorney, and contained a report of certain proceedings on the discharge of an insolvent, in which very strong observations were made on the claimant, the attorney in question.
Let me make sure
the defendant pleaded that the alleged libel was a true report of the proceedings, and the jury found the issue in his favor. But the claimant had judgment notwithstanding the verdict, because the heading contained an allegation against the claimant, which was no part of the report. It is open to question whether such authorities would be followed in the present day. In particular, the defense of fair comment may be available for comment on matters contained in a fair and accurate report of a judicial proceeding. 738. 705, per Bramwell in Riles v. Leader, 1866, LR 1X 296 at 300, per curiam, Way.
Okay, so just to say that again, or just to add some of the notes to this. A publication during the course of proceedings of any extraneous matter likely to prejudice the course of justice may be contempt of court, right? That's important. But both decisions must now be read in the light of the Contempt of Court Act 1981. And in relation to the publication of documents disclosed on discovery, see Home Office versus Harman. And in relation to the publication of documents disclosed on discovery, right? In Smith v. Scott, Coleridge J. directed the jury that they might find a report of proceedings in judges' chambers to be privileged, but the question whether judges' chambers are an open court was not discussed. As to liability for contempt, 1, for publishing details of the deliberations of the jury, see contempt of court. 2, publishing witnesses' name contrary to court's prohibition. And 3, contempt of court. As to publication of a writ, a newspaper is defined as any paper containing public news, intelligence, or occurrences, or any remarks or observations therein, printed for sale and published in England or Ireland periodically or in parts of or numbers at intervals not exceeding 26 days between the publication of any two such papers, parts, or numbers. There's nothing in this section to protect the reporter insofar as he makes a publication by sending his manuscript. There is a difference of opinion as to this, that is whether the section gives an absolute privilege or is merely declaratory of the existing common law affording a qualified privilege. If the preamble and the title of the 1888 Act are considered, it seems probable that the section extended the existing privilege in favor of newspapers and that it gives an absolute privilege. Right? In Mockery versus Associated Newspapers, Thompson J. held that the privilege was absolute. Okay. The Legal versus Hiley. Lord Goddard, C.J. held in Lasky v. Newark Advertiser Limited, the Times, December 3rd, 1946, that it was to the public interest that heckling at a public meeting should be reported. Right, so that is it for that section. Okay, so next class we will look at in the next class. We're still doing Clark and Lindsay. We're trying to finish Clark and Lindsay so we can move on to other texts. So the next class would be Parliamentary Reports 22-152. Okay, 22-152 is where we will be taking off from next class. All right, until then, have a good rest of your day or night, as the case may be, depending on what part of the world you are joining us from and what time of day and so on, or what time of night. Okay, so until then, have a good one. We'll see you soon. Bye for now. 22-152 is where we're moving on to next. Bye-bye.